It is late, and Rohan Reddy is doing the math that has nothing to do with his research. Not the hybrid quantum classical algorithm on the screen in front of him, the one groups at IBM and Google have started citing. A different sum. His daughter turns 21 in a little under 3 years, and somewhere in a government office, his green card case sits in a queue. His employer controls, and he does not. He is a quantum information scientist at the frontier of his field, and the thing keeping him awake is a birthday. We are breaking down everything you need to know. Check the timestamps on your screen to jump straight to the segment that impacts you more. Rohan is a composite, built from the kinds of cases we see, not a single real individual. But his situation is one we meet constantly. Here is the part he does not know yet, and the reason this episode exists. Everything Rohan needs to stop waiting on that employer already exists in his own record. He just has not been told he can file it himself. Hold that thought, because we will come back to exactly what was sitting in his file the whole time. You are watching STEM Meets Immigration from the law offices of Chris M. Ingram. A quick note before we go further. This is general educational information, not legal advice for your specific situation. Stay with us, and by the end, you will understand that a green card pathway that thousands of researchers on employer-sponsored petitions do not know they can pursue entirely on their own. The world Rohan works in. To understand why Rohan matters to the United States, you have to understand the moment his field is in. For decades, the promise of quantum computing was real but distant. Machines that could, in theory, solve problems no classical computer could reach, but only if you could get the qubits to behave. Qubits are fragile. They lose their quantum state through a process called decoherence, and without reliable error correction, quantum computers stayed experimental. That barrier has started to break down. In late 2024, Google's Willow chip demonstrated that error rates could fall exponentially as the number of qubits rose, the field's long-sought below-threshold milestone. For the first time, adding more physical qubits made the system more reliable, not just more complex. IBM has been executing a public roadmap toward fault-tolerant, quantum-centric supercomputing. Microsoft unveiled a different approach to error resistance with its topological qubit Majorana 1 chip in early 2025. And across all three, the language shifted. Not if, not someday. Within 5 years. Hartmut Neven, who leads Google Quantum AI, put it plainly, that within about 5 years, we will see real-world applications possible only on quantum computers.
Why the people matter as much as the machines. The applications being discussed are not abstract. Drug discovery, materials science for better batteries, financial risk modeling at scales classical machines cannot reach, optimization problems in logistics and energy that have resisted solution for decades, and the algorithms that will run on those systems, the hybrid quantum classical approaches that squeeze useful computation out of today's imperfect hardware, while the hardware matures, are being written right now by people working at the seam of quantum physics, computer science, and applied mathematics. Those researchers are among the most sought-after people in technology. They are also, in many cases, here on H-1B visas, brilliant, essential, and legally fragile in ways that have nothing to do with their work. That is exactly where Rohan found himself, and exactly what the right strategy was built to solve.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
Rohan's story. Rohan grew up in Hyderabad, the son of a software engineer and a mathematics lecturer. Numbers and systems were the language of the house. He was drawn early not just to computing, but to the edge of what computing could do, the theoretical limits and how to push past them. He completed his undergraduate degree in computer science and mathematics at one of India's premier technical institutions, then earned his PhD in quantum information science at a US research university. His dissertation focused on hybrid quantum classical algorithms, the class of approaches that pair quantum processors with classical computing to handle optimization and simulation problems neither can solve alone. After his doctorate, he joined a US quantum computing research organization. He published in leading journals. His papers began drawing citations from groups at IBM, Google, and academic institutions across 3 continents. He filed patents on novel algorithmic methods. He was invited to speak at major conferences. He mentored graduate students and served on program committees reviewing the work of his peers. By any honest scientific measure, he had built an extraordinary body of work.
The pressure underneath the success. And he had built all of it on H-1B status. Each year it renewed. The lottery was not his worry because his employer had maintained sponsorship through an approved I-140. But the traditional employer-sponsored route to the green card was long unpredictable and dependent entirely on decisions that were not his to make. His priority date was current. His profile was strong. But the process sat in the hands of an employer navigating its own funding cycles and priorities. Now, remember the sum from the top of this episode. He and his wife, Ananya, had 2 children, and the elder was approaching 21, the age at which a child can lose derivative status in a parent's immigration case and face a separate, far harder path to staying. He had watched colleagues wait, watched timelines slip, watched employers restructure. So he stopped waiting, and he reached out to the law offices of Chris M. Ingram. As attorney Chris M. Ingram explains, Rohan's profile is a familiar kind of case. A researcher who assumed the green card could only come through the company that hired him. What we saw was someone who had already built on his own a record that could stand as a self-petition. He did not need to keep waiting for permission. He needed to be shown that the evidence was already his.
I had an excellent experience working with my caseworker Laura on my immigration case. She was consistently clear, organized, and communicative throughout the entire process. Laura always explained exactly what she needed from me to complete her drafts, which made everything feel straightforward and manageable. I'm very grateful for her help and would highly recommend Laura and the law offices of Chris M. Ingram to anyone looking for a reliable and dedicated immigration services. What EB-1A is and why it fits researchers. So what did Rohan's lawyers see in his file that he had been trained not to see himself? To answer that, you have to understand the pathway they were reading it against. The EB-1A is an immigrant visa petition, a direct pathway to permanent residence for individuals of extraordinary ability in their field. Unlike the EB-1B, or the standard employment-based process, it requires no employer sponsorship, no labor certification, and no dependency on a company's willingness to file for you. The researcher self-petitions. If the evidence meets the standard, the case stands on its own. The standard is genuinely high. USCIS requires either a one-time major internationally recognized award or evidence meeting at least 3 of 10 regulatory criteria. And beyond the count, USCIS applies a final merits determination, weighing the whole record to decide whether this person truly sits among the small percentage at the very top of the field. Meeting 3 criteria is necessary. It is not always sufficient. That is why the quality of the petition, the framing, the expert letters, the presentation of evidence matters so much. 2 researchers with identical records can receive different outcomes based entirely on how the case is built.
How Rohan's record was built into a case. Now back to Rohan and to what was hiding in his file. The evidence package the law offices of Chris M. Ingram assembled was comprehensive and precisely framed. Scholarly publications in peer-reviewed quantum computing journals, with a documented citation pattern showing that researchers at the field's leading institutions were building on his work. That addressed the scholarly articles criterion, and the citation record also supported the original contributions criterion, showing his algorithms were shaping the direction of the field, not just adding to its volume. Peer review and program committee service at international conferences, establishing that those at the top of the field recognized him as qualified to judge their work. Patents on novel hybrid quantum classical methods, documented for technical novelty and industry relevance, presented as supporting evidence for the contributions criterion, rather than a standalone criterion of their own. High compensation relative to peers, established through salary benchmarking against published data, and expert letters from researchers of recognized standing, each specific to Rohan's contributions, each placing them in the context of the field's advancement.
The RFE, where a harder question made a stronger case. So the record was strong. It still was not a clean approval, and here is the moment the case turned on. USCIS issued a request for evidence. An RFE is not a denial. It is a request for clarification or supplementation on specific points the adjudicator has identified, and it demands a careful, targeted response. The wrong approach, a general resubmission, or a failure to address each point directly, can turn an approvable case into a denial. The RFE, in Rohan's case, challenged the framing of two criteria and asked for more on the originality of his contributions relative to the wider quantum computing field. The response the firm built was surgical. Each challenge point was addressed directly. Additional expert analysis explained in precise terms how his algorithmic innovations differed from and advanced beyond prior work in the literature. Additional citation evidence showed the downstream influence of his research on later publications. The response went back within the deadline. The petition was approved. Rohan is now a lawful permanent resident. Ananya and the children are secure, and the research continues.
A note on who this applies to. A quick word on eligibility because it matters. The EB1A is available regardless of your country of birth, and it is self-petitioned, so it does not depend on an employer. It does, though, require you to complete the green card the right way for your situation. Applicants already in the US, in a valid status, such as H-1B, may pursue adjustment of status once a visa number is available. Applicants abroad proceed through consular processing. These pathways do not repair a lapsed status. They assume you are either maintaining lawful status here or applying from outside. One country note, the EB1 category can retrogress for very high-demand countries such as India and China, so where you were born can affect timing even though the self-petition itself does not need a sponsor. Your status, your nationality, and your priority date all shape the route, so the specifics are a conversation to have with a qualified attorney about your own facts.
The aging out clock and why timing is strategy. There is one more thread in Rohan's story that deserves its own moment, because it is the part families miss until it is too late. When Rohan first called, his elder child was inside 3 years of turning 21. In immigration, that is not just a birthday. A child listed as a derivative on a parent's petition can age out, losing that derivative status, and the Child Status Protection Act, the CSPA, exists to protect children from aging out purely because of government processing delays. But the mechanics are timing sensitive and fact-specific, and the calculation of a child's protective age changed in 2025 toward a stricter standard. For EB1 cases, where visas are more often current, the interaction plays out differently than in the badly backlogged family categories. But different is not the same as safe. The point for every family is simple. If a child is within 2 or 3 years of 21, and you have a pending or approved I-140, the CSPA timeline needs a specialist assessment now on your specific facts, not when the birthday is in sight.
The action plan, if you are a researcher on an employer-sponsored case. Step 1. Take your own records seriously. The researchers who underestimate their EB1A eligibility are very often the ones whose work is genuinely cited, whose conference invitations are real, whose patents are legitimate, and whose field already treats them as a serious contributor. Pull your citation counts. List your peer review service. Identify every conference where you presented or judged. That inventory, assembled honestly, is often a surprise. Step 2. Have it evaluated by someone who specializes in EB1A, not your employer's HR team, and not a general practitioner. The framing and presentation of your evidence matters as much as the evidence itself. Cases with identical underlying records have produced different outcomes, based solely on how the petition was argued. Step 3. Anticipate the RFE instead of fearing it. In a highly collaborative field, expect the question about individual contribution within team output, and build the declarations and independent expert letters that answer it before you are asked. An RFE handled well strengthens the record rather than weakening it. Step 4. Understand where your family stands. If you have a child approaching 21, that timing is part of the legal strategy, not a separate worry. If your spouse is on a dependent status, their work authorization is part of the picture too. The strategy that serves your household is assessed as a household. Step 5. Move before you have to. The researchers who reach out with months of runway have more options than those who reach out mid-crisis. File from strength. While your status is stable, your record is current, and the timing is still on your side. As attorney Chris M. Ingram puts it, the researchers who come to us early are simply easier to help. Not because the later cases are hopeless, but because the earlier ones are built with room to breathe. The EB1A is a planning tool. Use it while the clock is still your friend.
Rohan is still here, still running hybrid quantum classical algorithms on problems that were, a few years ago, considered intractable. His patents are active. His citations are accumulating. His graduate students are carrying his approach into the next generation of the field. And his son, the one who was approaching 21 as his case moved through adjudication, is in the United States, secure, building her own future here. The people who will define the next era of computing, the convergence of classical bits, artificial intelligence, and quantum qubits that scientists like the Spanish-born Dario Gil have described, are already in the United States. Many of them are on visas. Most are doing work that cannot simply be replicated somewhere else, by someone else, on a different timeline. Rohan is one of them. Somewhere right now, a quantum processor is running an algorithm he designed. One quick question before you go, and we would like your answer in the comments. Keep it general, please. No personal details or case specifics. Which part of your own record have you been waiting for someone else to file for you? Just tell us the category: a paper, a patent, a citation, a role. We read them. If you want to see how a record like Rohan's gets built into a self-petition, visit breakthroughusa.com. The law offices of Chris M. Ingram has built EB1A petitions for researchers at the frontier of their fields for more than 2 decades. No employer required. As attorney Chris M. Ingram says, you are not waiting for permission to be extraordinary. You already are. Now let us document it. This has been general educational information, not legal advice. For guidance on your own situation, speak with a qualified immigration attorney